Good morning or afternoon to everybody. Thank you so much for joining us today. It looks like we have a number of people kind of still trickling in here. We do have a great group signed up for the webinar today. So hopefully that means you guys are super interested in this topic and looking forward to it. So just to a little bit of housekeeping and an introduction here. I did take a look at the attendee list. It looks like we've got quite a few of you who've listened to our webinars before, but we've got a bunch of new listeners as well. My name is Janelle Stanton. I'm the Vice President of Communications here at MyHR Counsel. I'm also a Senior Associate Attorney practicing employment and corporate law for the law firm that MyHR Counsel uses to staff its attorneys. So coming at you with both the communications background and a legal background as well. So I've been doing these Third Tuesday presentations now we're almost 2 years. We started this last January and we've had some good success with these. So hopefully you guys are enjoying these. I do want to talk about a little bit of housekeeping before we discuss the agenda. As always, we do record the Third Tuesday webinar. So this is being recorded and we will send out a copy of it to everybody who either signed up and did attend or didn't attend. So everybody does get a recording of this. So if you want to share it or you need to go back and re-listen to a part of the presentation after the fact, you will have the option to do that. We also put in the handout section on the webinar panel. If you look to the handout section, I did put a PDF of the deck there. So if you want to grab the presentation deck right now so that you can take notes on it, that is available to you there as well. Also on the webinar panel is the questions box. So if you have questions for me that you'd like me to cover, go ahead and put those in the questions box. Again, for those of you that have done my webinars before, I really like to take questions throughout. I think it kind of makes the presentation a little bit more interesting. It's not just me droning on about the law. So if you have questions, please ask them as we go, and I'll try to address them throughout. A couple of things. So we always do send out a follow-up email, and I always get a couple of people writing to me, 10 minutes after the presentation is done asking for their email. It does take some time for the email to download, so hang in there, and we will get your email with the presentation. We'll also send a Q&A, so I always type up the Q&A that we received during the presentation and send that out afterwards as well, so that you can refer back to that Q&A. You'll also get the HRCI credit code. So for those of you that are PHR, SPHR, or any of the other acronyms certified under HRCI, we did get approved for one credit hour of recertification credit for HRCI. You do have to attend the full presentation in order to get claim credit for the hour. So that will go out to all of the attendees. If you don't attend, unfortunately, you're not able to get that. And then we also will send out our survey. Again, we don't get very many survey responses, and I know that we're inundated every single day with surveys. I went to the doctor last week and I got a survey for my doctor's visit. I haven't received one of those before. I know that they're annoying, but last month we did a presentation, and now I'm trying to remember what we were talking about. We were talking about non-compete agreements, and somebody who attended took the time to do the survey, and this is the presentation that they asked for. So ask and you shall receive. I promise these webinars, I'm not this creative always to come up with all of this content on my own. So somebody else suggested this, and so we created it. So again, please, if you have the time, it's very short. Let me know how you think or how you felt about the presentation, what we could improve on, and topics that are of interest to you. So obviously this week or this month, we're talking about bullying in the workplace, what it is, what it isn't, and how to handle difficult employee situations. I just realized I never advanced my slide here. Sorry about that. Now you can see my mug here. And so what we're going to be talking about today, so we're going to talk about the difference between discrimination, harassment, and bullying. They are not the same things. They are three very different topics and very different legal analysis behind each one of these. And I will say that clients get these mixed up and have thoughts that, maybe they're the same, they're interchangeable, but they are very different and they have different legal analysis that is tied to them. So I'm going to cover all three, the definitions of them. I'll talk about some examples of bullying to kind of more specifically put a focus on what bullying is. We'll talk a little bit about the statistics, and I like pointing out the statistics here because I think that a lot of people have a tendency to overlook bullying because lawsuits regarding bullying are very difficult for an employee to be able to succeed against an employer on. So often we have a tendency to kind of look past bullying, but I'll talk about some of the non-legal negative implications for a company and talk about some of those numbers. We'll cover a few scenarios involving bullying, how to handle them. And then, of course, we always talk about this here at my HR Council, steps to prevent bullying in your workplace, because I do think it's very important that we're thinking about, in addition to discrimination and harassment, bullying and how we can keep that out of the workplace. I know we hear about it a lot at school, at, things like that, colleges, hazing, things like that, but it's still very prevalent in the workplace, as the statistics will show, and still very much a problem for companies. All right, so let's just jump right in. Again, I always like to start off with understanding the terms and making sure that we've got a good base of knowledge before we dig in. So discrimination, harassment, bullying, like I said, they're all very, very different. So with discrimination, employment discrimination laws, and there are many of them, and I'll talk about them in just a moment here, prohibit an employer from taking adverse employment action. So whether that's terminating, demoting, or cutting the pay of a current employee, or refusing to hire an applicant. So taking adverse employment action against employees and applicants based on their membership in a protected class. And so usually the way that I explain discrimination is to reference at-will employment. And most of you are familiar with at-will employment. Most states, not all, Montana, I'm looking at you, have at-will employment statutes, which basically mean an employee can quit their employment or an employer can terminate an employee at any time without reason. So you don't have to technically give an employee a reason for terminating them. However, one of the biggest exceptions to at-will employment is you cannot terminate or take other action against an employee on the basis of their protected class status. Protected class status is covered, again, by many federal, state, and local statutes. So, for example, we've got Title VII of the Civil Rights Act of 1965 that protects individuals based on race, color, religion, sex, national origin. But then we've got other laws like the ADA, the Americans with Disabilities Act, that protects individuals from discrimination on the basis of disability. We've got the ADEA, the Age Discrimination Enforcement Act, that protects employees age 40 and older. There's the Genetic Information Non-Discrimination Act, GINA, that protects individuals' genetic information. So employers cannot use an employee's genetic information to make employment decisions. So things like that. So there's, again, like I said, there's many different laws that define what is discrimination, what are protected classes. But the difference here that we need to think about is With discrimination, it's when an employer takes adverse employment action against an employee because of their membership in a protected class. There's a couple of forms of discrimination to be aware of. So obviously, we know about disparate treatment. That's the kind of overt discrimination that's prohibited. There are subtler forms of discrimination that are called disparate impact, so having policies and procedures that disparately impact a specific protected class. If you think about it, you may have heard of this. This was quite a while ago, but there was a fire department, and now I'm going to blank on the city, but they had various testing that the fire department had implemented. Firefighters had to obtain a specific score on the written test in order to move up the ranks. And a number of minority firefighters filed suit against the fire department, saying that the testing itself was discriminatory based on the way that the questions were phrased and some things like that. So that's disparate impact, which is also discrimination that is prohibited. All right, so that's kind of discrimination in a nutshell. I could talk about discrimination, obviously, for a full hour, but again, we're highlighting bullying today. All right, so harassment. Harassment is different. Harassment is a form of discrimination that happens when an employee or applicant is treated poorly because of a protected class characteristic or activity. So again, it's a form of discrimination. So individuals in those protected classes, like I was just talking about, based on race, color, religion, sex, national origin, age, disability, genetic information, all of those things still apply here to harassment. But rather than having an adverse employment action like termination or demotion, what's happening with harassment is somebody is enduring some type of offensive conduct within their employment. So whether that be words, actions, somebody who's creating an intimidating, hostile, or abusive work environment. But again, it's all tied back to that membership in a protected class. So for an employee to be able to assert a claim of harassment against an employer, one of the things they have to prove is that they were harassed because they were a man or a woman or a particular religion, a particular sex. Bullying then is a very, very different type of workplace behavior. So bullying is the repeated unreasonable actions of an individual or group directed toward a coworker. This can be anybody in the workplace that is intended to intimidate and create a risk to the health and safety of the target. But notice what's demonstrably missing here. What is missing is that bullying is not necessarily based on protected class status. So that's the big difference here. Somebody can be bullied for any number of reasons, and we'll talk about what those bullying actions are in just a couple of moments with some examples. But again, the big thing that's missing is the bullying is not related to membership in one of those protected classes. All right. So I came up with a quick little example here. This is to show discrimination versus harassment versus bullying. So Janet is an employee for XYZ Widgets Inc. Janet is discriminated against if she is fired because she is a woman. So, for example, if she announces to her boss, her manager, that she's pregnant, the manager says, "Hey, it's not a good time to be giving any pregnancy leave. You're terminated." Or, "Oh, this is a very physical job. You're pregnant. You clearly can't do this job. You're terminated." In that situation, Janet is discriminated against because she suffers an adverse employment action because of her protected class as a woman. On the other hand, Janet is harassed if her boss calls her a derogatory name because she's a woman. So if her boss is, hurling gender-related insults against her, that is harassment because she's being treated poorly because she's a woman. But bullying, Janet is bullied if her boss makes fun of her for being a Packers fan, even though the Packers are a clearly superior football team. Yes, I did make this presentation. I am a Packers fan. I've never been bullied for it, but I've definitely taken my fair share of gruff in an office in Minneapolis where everybody is a Vikings fan, but I digress. So in this situation, she's being bullied, and definitely I will say that sports can be a basis for bullying. That is 100% inappropriate in the workplace. A lot of times it's in good fun and in jest, but definitely there can be times when bullying, even regarding sports, does cross the line. So here, obviously, Janet is being bullied and being made fun of because she's a Packers fan. It has nothing to do with her being a woman. And so even though it could be inappropriate, it is not discrimination or harassment. Now, one thing I do want to take the time to point out regarding harassment, and a big point of confusion for employees. We hear this all the time from our clients to our employers that their employee is asserting a hostile work environment claim. Now, a hostile work environment is very different from somebody who's just being a jerk. A hostile work environment is a specific type of legal claim that an employee can lodge against the employer, and it's under the harassment framework. So a hostile work environment is when an employee is subjected to behavior that is severe and pervasive. So it usually can't just be one comment. Severe or pervasive, that it's attributable to the employer, that the employer knows about it, it has failed to take action. And again, that is based on protected class status. So I want you to remember, hostile work environment does not equal bullying in all situations. A hostile work environment is a very specific type of legal claim under the harassment umbrella. Somebody being a jerk in the office just because they're a Vikings fan or a Packers fan or whatever is not a hostile work environment. It may simply be bullying action. And again, it's definitely not appropriate in most situations, and things can really get out of hand quickly with bullying. So these are all what I would consider examples of bullying behavior. So spreading malicious rumors, gossip, or innuendo. So making stuff up about a specific employee. We've had this kind of stuff happen a lot with our clients. So one of the things that's big that's happening right now is somebody saying, "Oh, well, did you hear that Jane in the office has COVID, or her boyfriend has COVID, but she's here in the office anyway," spreading kind of rumors, gossip, things like that. We know it's kind of one of those things, when you see it, but that is an example and a very common example of bullying behavior. Excluding or isolating someone socially. This is definitely one of those behaviors that we see a lot after somebody files a discrimination, harassment, or retaliation claim. So if somebody complains about their supervisor, doing something wrong, or a coworker doing something inappropriate, and now the employee is being socially ostracized, not invited to happy hours, things like that, that is an example of bullying behavior. There can be situations where that actually rises to the level of retaliation that would be actionable against the employer. But if a group of employees is just like, "Oh, John complained about our manager, Cindy, and we really like Cindy, so John's dead to us, he's canceled," whatever, that is, something that is inappropriate and could be considered bullying. intimidating somebody, undermining or impeding a person's work, physically abusing or threatening abuse. Now, this is one area as well that would be bullying, but could also rise to the level of assault. And I'll talk a little bit about that in a couple of slides here, but kind of put a pin in that idea. Removing responsibilities without cause, so taking away something that an employee has been responsible for without any type of indication that they've been doing a bad job, but really meant more as a punishing behavior. Constantly changing work guidelines, so having a policy that says you've got to call in 7 days ahead of time, but you've got an employee you don't like, and so you're trying to get them fired. So all of a sudden, the requirement is that you call in 3 days ahead of time, or something like that. Inappropriately changing workplace policies to punish or get somebody in trouble. Again, there can be situations where that can rise to the level of harassing or discriminatory behavior, but a lot of times it's simply bullying just because somebody isn't liked, not necessarily because of protected class status. So remember, that's the big difference here. And establishing impossible deadlines, giving a deadline that's completely inappropriate and impossible to comply with. Withholding necessary information that an employee would need in order to complete their job in a satisfactory manner. Making offensive jokes and remarks. Again, that's a really big bullying category here. Employees that are, making jokes like that are offensive, that aren't related to protected class status, again, are something that it could be bullying behavior. Intruding on a person's privacy, digging through their private things, looking through their desk, assigning unreasonable duties. Like you have a janitor, but you don't like somebody, so you're making them scrub the toilets and replace light bulbs, and it has nothing to do with their role, their job duties, things like that. Underwork, this is kind of an interesting topic, and something I've actually read a few articles about regarding bullying, is creating a feeling of uselessness. So not assigning meaningful projects to somebody that is not liked in the office. So, we don't like a specific person, and so, there's an exciting project coming up, or there's something, something that needs to get done, but we don't want this particular person on the team. And so not giving them enough work to do, or not giving them meaningful enough work, again, is an example of bullying. Obviously, yelling or using profanity, again, depending on the profanity. Obviously, use of any sort of derogatory term on the basis of race or ethnicity rises to the level potentially of harassment or discrimination, but just using, sort of a run-of-the-mill 4-letter and 5-letter words may not necessarily go into the harassment or discrimination categories, but can for sure be bullying. Belittling a person's opinions, especially in meetings with other individuals. Unwarranted punishment, blocking attempts for somebody to get further training or leave or some type of promotion, again, without any basis, with really just not liking this individual being the basis behind that action. And then tampering with personal belongings, again. So just a bunch of examples for you to consider, especially if an employee comes to you to complain of something. I think this list could be helpful if you're hearing somebody say, well, I'm experiencing, my boss is not giving me meaningful projects and is putting other individuals with less experience on these projects. I don't know what's going on. This can be something that might trigger a discussion or an investigation into bullying behavior. So that's why I'm providing this list. Obviously, this list is illustrative and not complete. People's cruelty knows no bounds, unfortunately, so there could definitely be additional examples of bullying behavior that are not listed here. Okay, so the why with all of these types of claims matters significantly. And I'm going to go through each one because they are, again, very different with the why. So obviously in discrimination cases, one of the things that employers need to be thinking about is personal costs that your employee might suffer are very low. It is cheap and easy for employees to assert discrimination claims against employers. So a lot of times, employees don't need to retain an attorney, and they don't when they file a claim with the EEOC or a related state agency. So, for example, if any of you are California employers, you know there's billboards out there that tell employees that they've got rights. There's a website where employees can go to and very easily file claims of discrimination against their employers, and it's free. There's no charge to it, unlike filing a case in court where there's a filing fee and usually there's an attorney involved. Filing those types of complaints with the EEOC is free. And the EEOC will do an investigation of your employee's claim. And if they think that discrimination happened, the EEOC and state agency, they issue what's called a right to sue letter. And with those right to sue letters, employees are going to be able to hire an attorney on what's called a contingency fee basis. Often, not always, but often. Contingency fee means that your employee only pays that attorney if the attorney is successful in collecting for them. So again, cheap and easy for your employees to bring these. And then the big problem, of course, on the employer side is that there's big financial losses that come with these. Even if you settle the case, you're looking at definitely thousands of dollars in settlement fees. If it goes to litigation, obviously we all know this, litigation is very expensive, even if it's a meritless claim, even if your employee's claim is completely bogus, because believe me, I've read some very bogus letters that my clients have gotten from employees' attorneys saying that, my client discriminated against them on the basis of what have you. So even if they're meritless, it still costs money to have to defend those types of claims. With harassment, the why matters. Again, the number of harassment charges over the year has remained steady. There was a fairly large uptick after the Me Too movement in 2018 really took off. But just kind of a number here for you to think about. In 2019, the EEOC received 26,221 harassment complaints. That number is typically hovers between 26 and 28,000, but that's still a lot. And again, just like discrimination, harassment claims expose employers to significant liability. Even if your company carries EPLI, which is Employment Practices Liability Insurance, if you don't, here's my plug. I don't sell it, so I can tell you, make sure your company has Employment Practices Liability Insurance. It is absolutely crucial should you face employment litigation. Often it does have some fairly high deductibles. It's not uncommon for deductibles to be $25,000, $50,000. But when we're talking about lawsuits like there was a case, 2012, where a harassment claim, and I believe this is in the state of California, but the jury awarded a $168 million verdict in a case alleging sexual harassment. So these juries can be very employee friendly. Obviously, this gets very expensive, but EPLI can help you cover maybe not that extent of damages. It sounds like there's probably some, intentional action in that kind of case. But just my plug, you heard it here. Make sure you have EPLI. Another big problem with harassment cases is consensual office romances often result in claims. So what happens there? We all know when one employee decides to end the romance, the scorned lover can sometimes try to bring harassment claims, saying that they were sexually harassed by the other party. And so, that can be attributed to the employer, especially if the relationship is between a supervisor or manager and their direct report. So, definitely harassment claims come. It occurs over social media. It occurs during happy hours. It makes it very hard for employers to detect and address that, especially if people aren't coming forward right away. And years later, after a tough breakup, now they're saying that there's harassing behavior. So, but then like all things, there's a definite non-legal negative side effect for harassment. Loss of productivity is a huge one. Obviously, employees who are being harassed when they go into the workplace, maybe they're scared that their harasser is going to be approaching them, or they can't focus. They're worried about, they're worried about things like if somebody's going to find out, if they're going to experience harassment that day, things like that. Negative publicity. It's not just the biggest companies that receive negative publicity relating to harassment claims. I've seen even in our small newspapers here in the Twin Cities where I am, smaller companies have very bad reputations for treating their employees poorly. And having that get in the newspaper, it's bad for business all the way around. People aren't going to want to do business. We're kind of in that cancel culture, as it were anyway. If the one pretty famous example, Soul Cycle. I love Soul Cycle. Anytime I'm in New York or DC, I always go to Soul Cycle. But their CEO held a very expensive per plate fundraising event for Donald Trump. And so people boycotted Soul Cycle, and there are other options out there. They have competitors, of course. And so that kind of negative publicity really can impact a company's bottom line, even if litigation has not ensued. And even if the claims and allegations against your company don't even turn out to be true. So social media does kind of create a firestorm there for employers. But then, of course, bad employee morale and high turnover. And we all know as HR professionals that turnover is very expensive. It is much more affordable to keep a current employee than it is to interview, train, and bring up to speed a brand new worker. So having high rates of turnover, again, impacts a company's bottom line as well. But then let's get into the why about bullying. Bullying is a little different here because, again, lawsuits that assert bullying can be very difficult for employees to succeed on. Again, because the underlying motivation for the bullying is not related to protected class. So, unfortunately, there's not a lot of avenues for litigation for employees who are bullied. There are lawsuits for infliction of emotional distress. These can be either negligent or intentional. So this is a type of tort or civil claim that's recognized by state law. But again, they're very hard to prove, and they can be really difficult. And part of the problem is in order to claim a valid intentional infliction of emotional distress claim, plaintiffs have to plead. They have to put in their pleadings and prove that either the bully or the employer acted intentionally or recklessly and exhibited extreme and outrageous behavior that caused the distress. So that's a high bar to reach to show that this conduct was extreme and outrageous. There was a case called Denton versus Chittenden Bank. This is an older case, but it's still very relevant. And what the judge what the court in that case said was that mere insults, indignities, or annoyances that are not extreme or outrageous don't provide the proper foundation for an IIED claim. And so again, that extreme and outrageous bar is set very high. So it can be super difficult for an employee to be able to show that bullying was to that level. Now, it doesn't take a stretch of the imagination to say, well, there could be situations where bullying is so extreme, so pervasive, so long lasting that it could actually create a claim for intentional infliction of emotional distress. Some states, not all, recognize what's called negligent infliction of emotional distress. Again, those cases are really difficult for employers or for employees to claim. It is possible that an employer could be held liable for negligence if it fires an employee based on actions. But again, it really has to in order for an employer to be held liable for negligence, it's likely going to have a tinge of discrimination or harassment. There's going to probably be needing some type of tie back in to the employee's protected class status. Part of the reason it's so difficult to bring these claims is because employees in the workplace have an exclusive remedy when they are harmed in the workplace, and that's workers' compensation. So outside of discrimination and harassment, if an employee is treated poorly or injured at work, workers' compensation is really the only claim that's going to lie there. So that's why this becomes very difficult. We have seen some violations of OSHA, the Occupational Safety and Health Administration, because employers do have a duty to provide a safe working environment to their employees. So they have a duty to do compliance inspections and do investigations, and OSHA can issue citations for violations of that. And there's two clauses that OSHA is going to look at here. So to see whether an employee or an employer can be held liable for bullying actions. But so first is what's called the general duty clause. That requires an employer to provide a workplace that's free from recognized hazards that are causing or likely to cause death or serious physical harm. So if an employee is physically accosting one of your other employees and bullying behavior, obviously OSHA could step in here and apply the general duty clause to fine you. Then there's also another section that requires that an employer comply with OSHA standards. And again, those are standards to keep your employees safe. I did have you put a pin in the idea of assault. In rare instances, assault charges could be actionable against an employer. There was a case called Rays versus Dosher, and that's from Indiana. And there, a court recognized a claim of assault based on workplace bullying. They upheld a jury verdict awarding $325,000 on an employee's claim that the defendant aggressively and rapidly advanced on the plaintiff with clenched fists, piercing eyes, beet red face, popping veins, and screaming and swearing at him. So in that situation, assault, and remember, assault is not battery. Assault is the fear of an intentional touching. Battery is actually if this employee had hauled off and hit him. But in this case, this person had such a fear that they were going to be hit and was being screamed and sworn at. And then in that situation, the jury awarded $325,000 on an assault charge. So I will say that's not common, but in those rare circumstances, it can happen. So kind of a couple of numbers here. There was a survey done in 2017 by the Workplace Bullying Institute. They did an online survey of 1,000 adults. And again, this was back in 2017. But of those 1,000 adults that were surveyed, 9% had experienced workplace bullying, either presently or in the last year. But if we extrapolate that number to apply to the general U.S. workforce, there's over 14 million workers that have experienced workplace bullying. That's a huge number, and this is why, like I said, it's a huge issue for employers because, and I think I may have glossed over the last part here, because lawsuits are so difficult for bullying, again, we're looking at those non-legal effects: loss of productivity, negative publicity, bad morale, and high turnover. These are big numbers, and you want your employees working to the fullest of their capacity, feeling safe, so that they are generating the maximum amount of revenue for your company and doing the best job that they can. I don't think that this is super surprising. These statistics bear out for harassment and discrimination as well. But 70% of workplace bullies are men. Male perpetrators seem to prefer women as targets at a rate of 65%. And women bully women in 67% of cases, which I will say is sad, a sad commentary on today, which is the 100th anniversary of the passage of the 19th Amendment, giving women the right of suffrage. So women have some work to do to lift up other women in the workplace here, obviously, as this figure shows. Again, not surprising, 61% of bullies are bosses. This is a huge issue. Imagine how your employee feels if their bully is their boss. They're going to feel like there's no outlet for them. So, and usually it's more common for the target, so the person being bullied, to leave than for the perpetrator to be terminated. And again, that's a very sad commentary. That should not be the case. Workplaces should be taking the side of the target, the person who's being bullied, and get rid of the perpetrator either through termination or discipline. I mean, that's really a very sad statistic and figure to me, again, especially because that perpetrator, that bully, is going to continue bullying others in the workplace. And unfortunately, I think with 61% of bullies being bosses, it can be hard. You can be put in a tough spot as an HR representative to have to try to reprimand or maybe terminate a manager who might occupy a role higher than your own. You might have a bully as a CEO, and that puts you as HR in a very complicated position. How do you tell the CEO who owns your company that they need to knock it off? I mean, you can't fire them, but ultimately, if it's their business, they may run it into the ground, and that's their business. But you as HR still have an obligation to raise the issue regardless of how high up the individual bully is. So I know that's hard. I've definitely counseled clients on that issue before. There are a couple of states that have anti-bullying laws on the books. There's only 3, Tennessee, California, and Utah. I will say that I think this is something that continues to turn through the legislatures in the various states and is something that states are paying a lot of attention to. So I do think these laws will continue to be passed, and employers should stay on top of these, because if you are subjected to one of these acts, you want to make sure that your company is complying, obviously. But Tennessee, for example, has the Healthy Workplace Act. It prohibits workplace bullying in the public sector, but it does say that public and private employers are immune from liability if they adopt a policy compliant with the statute. So if you're in Tennessee and you put in place a compliant anti-bullying policy, you're not going to be subject to liability if an employee tries to sue you. Now, like I already said, suing an employer because of bullying is already very difficult, but that kind of immunity guaranteed by a statute is very powerful. So if you're in Tennessee and you don't have one of these policies, reach out to our attorneys. We'll get you one ASAP. Not surprising to anybody, but California's Fair Employment and Housing Act does have a requirement that you train your employees on prevention of abusive conduct in addition to sexual harassment. So if you're in California, you're aware of the requirement to train your employees and managers on sexual harassment, but you need to include abusive conduct in that as well, which is essentially bullying. And then Utah's got an act as well, but that only applies to state executive agency employees. So it doesn't apply to private employees or employers, sorry. So a couple of scenarios here for you guys to think about. So this is actually based on a real case. All right, so faced with financial struggles, the CEO of Acme Auto Parts hired Robert Green, a turnaround specialist. I've never heard of a turnaround specialist, but that'd be quite the stressful job, I can imagine. Unfortunately, Green's management style did not mesh well with some of the employees, and I wouldn't call this a management style, as I would call it he's a jerk. But he often yelled, used profanity, threw objects, made physical threats, and was generally difficult to work with. Like I said, that is not a management style. That is somebody who is just a straight jerk. One man and 3 women had complained about Green's abusive behavior to their production manager. One of the employees also took the time to write a complaint detailing this behavior. The employee's manager relayed the complaints to the general manager and the CEO, and because of the actions in the employee's protest, the CEO removed Green from his position. So in this situation, I would say that the CEO did the absolute right thing by removing the bully, but obviously we have a case here anyway. 3 of the employees filed a lawsuit against Acme Auto Parts, name protected to protect the innocent here, alleging, among other things, discrimination on the basis of gender. All right, so going back to my first slide, what results? And I wish we could have it interactive discussion. This would be a lot of fun, I think, but I'm going to give it a second. Okay, what's the result? So obviously here, what we talked about is 1 man and 3 women complained about the abusive behavior. And our fact pattern says he yelled, used profanity, threw objects, made physical threats, and was generally difficult to work with. But in this case, the critical issue is whether members of one particular sex were exposed to disadvantageous terms or conditions of employment to which members of the other sex were not exposed. And here, the record shows, and our fact pattern shows, that both men and women equally fell victim to Green's abusive management tactics. So because of this, because we don't have any indication that Green was a jerk specifically to women, or that his treatment was motivated by some sexual desire or sexual discrimination, there is no claim for gender discrimination here. And the actions were inappropriate, but the CEO removed him from his position, which again, absolutely the right thing to do. And so because of that, the plaintiff failed. The employee's lawsuit against Acme Auto Parts failed here because, again, there was no ability to prove that Green was treating people differently because of protected class status, here being sex. One thing I do want to point out here is the idea of an equal opportunity harasser here. And this is something that I would call the jerk defense that employers could employ should they find themselves in this situation. What the equal opportunity harasser is somebody who engages in harassing behavior against several people, but not because of protected class status. So a lot of times employers will prevail on harassment claims by showing the employee was not subjected to mistreatment because of protected class status, but like I said, because the harasser was a jerk. So in this situation, the employer, Acme Auto Parts, is successful on the jerk defense because this guy, Green, was an equal opportunity harasser. And again, they did the right thing. Now, had they not removed Green, allow that to continue, here in this situation, part of the claim was the employees claim retaliation for complaining, and because they were terminated. So that is a different situation. And again, if they had allowed Green to continue, I think that there would be more issues for Acme Auto Parts here, but they did the right thing. And, you know, his jerk behavior was not based on sex. Changing the facts slightly, what if the insults were predominantly aimed at women, included comments about a woman's proper place being in the home and not in the workplace, leering and making sexually explicit gestures. So this actually comes from a different case. But obviously here, the treatment was motivated seemingly by both sexual desire for women, given the leering and sexually explicit gestures, but also sex-related stereotypes about women. So this case, obviously members of one sex were exposed to poorer conditions of employment because of their sex. And now in this situation with this particular case, these employees would be successful, potentially, in bringing a claim against Acme because of the discrimination and harassment that they had experienced. However, what I will point out is I think that these, unfortunately, these women, if this was a real lawsuit, they would still have problems bringing this case because Acme terminated Green after the complaints came out. So the complaints were made, Acme investigated the situation, and they took clear action against Green to terminate him. So in this particular situation, I still think Acme is going to be successful, but this is definitely much more of harassment rather than bullying because the actions are obviously motivated by protected class status, either hatred or dislike or what have you. You guys are probably going to understand, you're going to get this one too, I'm sure. But so a writer of the show, who's a male, claims that one of his former bosses, who was a female, called him an effing whiner and claimed that the show was toxic and demeaning, rife with bullying. The employee, the male writer, sends around an email alleging other examples of slights at the hands of his manager. The show then fired the writer. So what's the result here? So again, here, it does not appear that this man, and of course, men can assert hostile work environments and harassment claims as well. Men are in a protected class status, their gender. So I've talked to clients before who felt that white men who are Protestants or Catholics are not protected in a protected class, but they are. Because they're a white man of a particular religious faith, that means they're a protected class. So pretty much everybody is in a protected class. That's not even a question. So in this situation, the court here said there isn't a general civility code that requires that workplaces be happy, fuzzy, good-feeling places. But it does obviously say that using abusive language, gender-related jokes, things like that would contribute to a harassing environment. But here, this boss said that he was an effing whiner and supposedly there were other slights that the manager had levied. So because of that, there's no behavior that's directed at this employee on the basis of gender. So there isn't a hostile work environment claim. Again, it might be a toxic and demeaning bullying situation, but it's not actionable against the employer. What is a problem here is this employee engaged in protected activity when he complained about the behavior. So it is possible that there was a retaliation claim that lies here, which is a great way to dovetail into our last slide on how to prevent bullying in the workplace. And I'll just jump right to number 4 because I was just talking about it. Take all complaints of bullying seriously. Again, even though lawsuits may not arise from a bullying claim, it still is important to take proactive efforts to curb bullying behavior in your workplace. Again, to make sure that you're fostering an inclusive, productive work environment that has a good, strong morale. I recommend putting in place an anti-bullying policy, not only for the state of Tennessee, where it will provide you some immunity, but for all employers, it is a good idea to have a policy. If it's in a handbook, that's great. If it's in a standalone document, that's great too. But telling them what is bullying behavior, that it's not acceptable, and that it will subject somebody to discipline, including and up to termination. I think it's really key. And you guys all know I harp on documentation and policies all the time, but it's because they're really important in HR. Make sure that you enforce your policies consistently. Now, this is an area where, if you're not enforcing policies equally, you could face a discrimination claim if you're allowing one type of employee to get away with saying negative things, but you're not allowing a different employee to get away with the same thing. So if you're allowing a minority employee to engage in bullying behavior, but you're not allowing a woman, for example, to engage in the same behavior, that's when you're going to end up with a potential discrimination claim. So make sure you enforce the policies consistently amongst all of your employees. Again, I'm always a big proponent of training. Outside of the state of California, I'm not aware of any other place that requires anti-bullying training, but I think making it part of your harassment and discrimination training, sexual harassment, discrimination training, is a really good idea. I definitely recommend giving your managers a little extra shot in the arm on the training of this so they can pick out what is unacceptable bullying behavior and know how to report it to HR and when to take it there. So that's what I've got for you guys today. Like I said, my whole point in the presentation today is really to make sure that you guys have this on your radar. Yes, it doesn't lead to the same types of litigation and lawsuits as harassment and discrimination, but those non-legal side effects of bullying are real, they're pervasive, and they can be just as expensive for companies to have to deal with in those situations. So I just wanted to put this up here. Again, we still have our COVID-19 toolkit up. So for any of you that haven't accessed it, there's quite a lot of resources, forms, and things like that on the website. We do have information here if you have questions about subscribing to My HR Council. You can contact us. Our information is there to the left. If you're ready to get signed up, which we hope you are, you can do that with the link there on the right. I don't have any questions that have come in. If I know we're about a minute out, if anybody has any questions, feel free to put them in the chat box or the question box there. I'm happy to answer them. All right, not seeing anything so far. So I think with that, then what I'll do is I'll go ahead and end the presentation. if you're too embarrassed to ask the question live, or you just want to do that privately, go ahead and like I said, our email address is there, and we hope that you'll join us next month. Topics to be determined. Do our survey. I will make sure that you guys are getting the content that you want. Look for the follow-up email with the recording, the slides, the HRCI credit code, and all of those fun things. So thank you so much, everybody, for attending today. Have a wonderful day. Stay safe and stay healthy out there.